There's no way to know whether or not your case qualifies as uncontested. The only way to qualify whether it's uncontested or not is if the two parties actually agree. A lot of people will call and say, I have a completely uncontested divorce, but we don't agree on where the children are going to live. We don't agree who's going to pay child support, and I want to have all the assets. That's not uncontested. Uncontested in an attorney's eyes is somebody contacts you and says, hey, look, my spouse and I have decided that we're going to get divorced. We'd like to do it with just one attorney, which then we have to let them know we can't do it with just one attorney as far as representing you both. But if your spouse doesn't want to get an attorney, which we would advise him or her to get an attorney, but we can draft pleadings, we can assist you, meaning the client, in coming up with strategies and plans for implementing this agreement, whether it be for temporary orders or whether it be for a final actual decree. Uncontested could have various moving parts. You could have uncontested on the front end where, yeah, we're totally uncontested on the temporary orders. We know what we want. We're just not sure how we're going to finalize it. All the way to we have a full-blown agreement. It's going to be totally final. Please file my petition for divorce. Get a waiver for my spouse. The spouse signs the waiver. We get it back. We file it. You have to wait your 60 days from the date you filed to get your agreement entered with the court as a final decree. And during that waiting period, we get the agreement, we draft up the final decree, and we get it entered with the court. Now, there are issues in the interim. Can you think of any things that sometimes occur while we're trying to get uncontested divorce solved?
Well, and I've often found that people will call and say they have an uncontested divorce and they've never even spoken to their spouse. They know what they want as far as all the terms and conditions and things like that. And so it does require that they've had some communication with the other party so that they know what it is they're getting into. In the interim, between the time we're doing the original petition and waiting for that 60-day time clock to expire, there could be issues in regards to interim child support, who's paying the bills in the meantime, who's going to live in the residence, are we going to go ahead and put it on the market to sell, are we, who's going to be taking care of the day-to-day necessities for the children. So those are things in an uncontested divorce. If the parties have reached agreements for that, fantastic. But in contested divorces, that's typically what we use temporary orders for, so that we can put some of those orders in place to make sure that people can move forward on a day-to-day activity. So hopefully, if it is uncontested, they can agree on those issues and it not become a contested issue as we proceed.
Right, and I'll have people call in and say, well, what's ordinary? Every single case is a thumbprint. No one's case is alike. Nobody has the two same parties that are clones of them are getting divorced. Their children aren't the same. Their circumstances aren't the same, whether it's where their children go to school or how many children they have or their ages or, whether or not there's any medical issues with mom or dad or the children or financial things. Everything is a thumbprint. So when we do this, the number one thing that I think all people that are possibly going through a divorce or that are going through a divorce already, they need to make sure that they get an attorney that they feel comfortable with, that can provide them sound advice on strategies on how to move forward, what to do, and not just, hey, hire me and I will win and I will get all your rights and you won't have to worry. There's always an ulterior motive, unfortunately, and we hear these things all the time. I can't tell you how many times I have clients call that say, gosh, I wish we would have found you at the very beginning, because that's not what we were told. One thing here at Turner-Monahan that we're just not going to tell you what you want to hear. We're going to tell you what we believe is what's best for your circumstances. Sometimes that's a completely amicable resolution that you've come up with. Other times you might think it's a great resolution and we say, unfortunately, that's really not going to work and we think XYZ should occur.
Yeah, it's often with uncontested divorces, parties want to just say, oh, we'll just do visitation as agreed, or we'll just agree upon these things as time progresses. Well, because of our years of experience, we've seen things like that fail so many times, and then it's impossible to enforce those kinds of things later on. So that's where typically having attorneys who are extremely experienced in these things can go, okay, here's the pitfall with that. Here's the problem. I know you're trying to all work together and do co-parenting and do those things, and you can't. But there needs to be something more specific in your order as a default mechanism in case y'all get into a position where you don't agree in the future. And that's the piece of advice that comes with experienced family law attorneys that can help make sure that even in the uncontested divorce, where individuals are getting along, that they're protected on the back end in case something does go south somewhere down the line. Because oftentimes, and particularly when there's kiddos involved, that could be a very long period of time you're having to deal with the other spouse. So making sure you don't have to constantly come back into court is a strong benefit.